On the morning of March 21st of 1966, David Paul O'Brien and three partners burned their eraser cards on the steps of the South Boston courthouse, in front of a crowd that included several FBI agents. After, the four men were attacked by the crowd, an FBI agent put O'Brien inside the courtroom and informed him of his rights. O'Brien proudly confessed to the agent and produced the shared remains of the certificate. He was later charged with violating Section 462b3 and standing trial in the U.S. District Court from the District of Massachusetts. O'Brien insists on representing himself in his trial and argued that the law was unconstitutional. He explained to the jury that the burn the draft of the card publicly persuaded others to oppose the war. He said that others would reevaluate their position with the Selective Service, with the armed forces, and reevaluate their place in today's culture with law consider my position. O'Brien was convicted and sentenced to a maximum of 6 years as juvenile delinquent. It is important to clarify that at the time of the events, the Vietnam War was taking place. This situation was as aggravating on O'Brien's behavior. What is the importance of the draft card in the facts of the case? In 1948, the United States instituted a peacetime draft of the Universal Military Training and Service Act, also called the Selective Service Act, which required all male American citizens to register with a local draft board upon reaching the age of 18. In 1965, Congress amended the act to prohibit the willful destruction of the draft cards or registration certificates. These were small white cards bearing the registrant's defined information, the date and place of registration, and his selected service number, which indicate his state of registration, local board, birth year, and his chronological position in the local board's classification record. The Act had already required all eligible men to carry the certificate at all times, and prohibit alteration which would perpetrate or forgery or fraud. The 1965 amendment, however, made it a separate crime under 462b3 to knowingly destroy or knowingly mutilate the card. This amendment was passed at a time when public burnings on draft cards that protest the Vietnam War were a growing phenomenon. Many observers, including the U.S. Court of Appeals for the First Circuit, believe that Congress had intentionally targeted such protesters. Legal problem. The act of Paul O'Brien at the time of burning the draft card in front of the FBI agents constitutes a constitutional violation of the First Amendment.
Court decision Chief Judge Warren's decision was to reject O'Brien's argument based on the First Amendment, saying there is no breach of the guarantee of freedom of expression because O'Brien's conduct was an expression against war of Vietnam, and the amendment is justified for a government interest. The court rule says that draft cards are not of superfluous notification of registration. On the contrary, they overtake property the system performs, easing the registration and the local draft board, allowing notification to the board, change of duration, and finally preventing fraud and forgery. Moreover, it is considered that first gather the faculties of the court are to deliberate about the cards, try to advance properly the system performs. No relation is observed between the suppression of the discourse with the operation and the registration and evolution troops. And finally, there is no other alternative mechanism or means for the government to ensure that cars will continue to be available. Concurrence of Harlem. At first, he agreed with Warren, adds that it triggers an effect of preventing the speakers to reach a meaningful audience that could not be reached legally.
Importance of the case. O'Brien confirmed the power of the government to prosecute what was becoming a pervasive method of protest against the war. However, his greatest legacy was his application of a new constitutional standard. The evidence articulated in O'Brien has been used later by the court to analyze whether the laws that have the effect of regulating speech, although they are ostensibly neutral with respect to the content of the speech, infringe the First Amendment. Although the O'Brien test has rarely invalidated the laws that the court has considered neutral in content, it has given them an expressive behavior from the use of black armbands to the burning of flags and additional to the invoke against the prohibition.
Conclusion. A criminal prohibition against the burning of the recruitment card which does not violate the First Amendment is ruled. Since the effect of this speech is only of an accessory nature and is justified by the interest of government in maintaining an efficient system of military recruitment.